The police raided a rapper's house, found nothing, and then sued him for showing what they did. The case was never going anywhere, and it exposes something that most people misunderstand about government power. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. In 2022, sheriff's deputies in Ohio executed a search warrant at Afroman's house. They were looking for drugs, and they found none. But Afroman had security cameras running all through his house, and he later used the footage of the deputies searching his home in his music videos and certain social media posts. So then the deputies turned around and sued him for invasion of privacy, emotional distress, and misuse of their likeness. Predictably, the lawsuit went totally sideways, and the public reaction has been, frankly, gleeful, and for good reason. Because at the gut level, people understand something that the deputies seem to have forgotten. When you exercise government power, you don't get to hide from public scrutiny. That instinct isn't just cultural. It is also legal in a number of concrete ways. The law doesn't just allow the scrutiny of government actors, it actually insists on it. In fact, across multiple areas, the law systematically favors private citizens over government actors in tangible and enforceable ways. And that's the point of this video, to point out that the law puts its thumb on the scale against the government on purpose. Now, let's start with the clearest example. If you're a private citizen and someone defames you, you typically just have to prove negligence, specifically that they did not exercise their duty of care in checking the facts before they communicated something false about you. But if you're a public official, you have to prove actual malice, that the statement was knowingly false or made with reckless disregard for the truth. This concept has been confirmed by the U.S. Supreme Court in a case called New York Times v. Sullivan. The rule is simple. The law protects the criticism of government, even if that criticism happens to hurt individuals who are members of the government. Now let's flip the concept. If a government employee speaks out as part of their official duties, they generally do not have First Amendment protections for that speech. Again, the U.S. Supreme Court confirmed that in Garcetti v. Ceballos. If you're a private citizen, you can say almost anything. I've covered the few exceptions in another video. But if you're a government employee speaking as the government, your speech is not necessarily protected. Because when you speak for the state, you don't get to claim personal rights against it. Public employees also have fewer privacy rights at work. Government employers can search offices, review files, and investigate conduct. They don't even need probable cause to believe that you've done something wrong. The rule is reasonableness, not warrants. Again, this is because inside government, accountability outranks privacy. The same goes for political speech. Public employees face limits that private citizens don't. There are limits on their ability to advocate for certain elected officials and for certain public policies. And there are especially strong prohibitions on using their public authority to advance a certain political position. Now, a key example there would be Kristi Noem making videos blaming a government shutdown on the Democratic Party, which was both political and factually false. The Hatch Act and related laws impose additional constraints on government actors and their political speech, not fewer. Now let's bring it back to Afroman. The courts recognize a First Amendment right to record the police and public officials performing their duties. Why? Because government action must remain visible to the public. So what exactly were these deputies claiming? A right to privacy while executing a search warrant as agents of the state inside someone else's home on cameras that they did not control. That is not a private conduct. That is quintessential state action, the performance of explicitly governmental functions. And the law consistently favors exposing that, not hiding it. The reality is there is a trade-off to public service. You get authority, you get discretion, you get power backed by law. You get to drape yourself in the trappings of authority and power. But in exchange, the law subjects you to scrutiny, reduces your privacy, raises the bar on silencing critics, and exposes your actions to the public. That's not a bug. That is a design feature of the American system of government. Sunshine is the best disinfectant. Transparency in government is essential to good governance and rooting out corruption. In that context, the Afroman case isn't about making a music video. It's about basic rules of a functioning democracy. The government doesn't get privacy from the people. The people get privacy from the government. And the government can't insist on transparency into your life, but you, as a private citizen, absolutely can and should insist on transparency from your government. Hey!